Hey y'all. I did this whole video on the Zachary Hughes trial today and the potential for a mistrial, if anyone had moved for that yet. And there's a lot of chatter on Twitter about whether the prosecution can move for a mistrial. And if so, would it even be granted? And could he be tried again in double jeopardy? And then I realized that it didn't actually record any of the video, it just recorded my screen. I did intend to record the screen and show you the case that I wanted to show you, but I also thought it was recording video. So I'm going to tag this video clip onto that one. I'm learning about editing. I'm not very good at it, but I'll get there. All right, y'all. I hope this is a little bit helpful. If not, clearly let me know. But that's why the first 6 minutes you're just looking at my CapCut platform. I'm gonna get it one day. All right, y'all have a good night. Bye. Hey, y'all. Crazy day in the Rose Petal murder trial. And I just wanted to jump on here really quick because I've seen a lot of commentary about whether Zachary Hughes can be retried if there were to be a mistrial. And I think there's a lot of confusion. There were some comments from some legal commentary on X that I think prompted some confusion. And I believe the comment was basically the state cannot request or move for a mistrial, which is not true. The state can move for a mistrial. I think the person went on to clarify that what he meant was that absent a showing of manifest necessity, which is a case law doctrine from a Supreme Court decision. I believe it's Arizona v. Washington, maybe, I think, that in order for double jeopardy to, if a criminal defendant is going to be retried and there's a mistrial and the criminal defendant is going to be tried again, in order to avoid double jeopardy, there has to be a showing of manifest necessity or a strong public need. And so I think the person on X clarified this, but I wanted to just give you an idea of where this is coming from. There's no bright line test for, quote, manifest necessity. And I think the person's point, the attorney's point on X, was that it's relatively rare for the state to ask for a mistrial. And it is. It's more often the defendant asking or moving for a mistrial. But that doesn't mean it doesn't happen. And sometimes it's been in the case of extremely prejudicial evidence being introduced, which I want to show you a case related to that, an actual South Carolina case. It is, for instance, like I think in one case, attorney died in the middle of the case, or a material witness was unavailable. So it has to be a pretty extreme circumstance, but that doesn't mean that the state can't move for it. And it doesn't mean that it wouldn't happen. If it were to go, to appeal, let's say that the judge granted a mistrial and state moved for a mistrial and then the defendant opposed it and appealed it, the trial judge is going to be afforded pretty broad discretion, and that's kind of a general rule. The appellate court finds that the judge abused their discretion, and that is a term of art in the legal world. They're not going to upset the trial judge's discretion, and the rationale is the trial judge was there, the trial judge, the evidence, and is the closest to the case to have made that decision. So they're going to be afforded a wide degree of discretion.
and they're not going to upset that decision without some significant reason. There was a case in the Fourth Circuit. So South Carolina is in the Fourth Circuit when it comes to the U.S. appellate system, just like North Carolina. And I should say, I am not a South Carolina attorney. I am licensed in North Carolina, and this is not legal advice. I'm simply conveying this for education and entertainment. I know a lot of you are true crime fans, and these part of why I've started this channel is to explain some of these concepts. But that being said, I'm not a South Carolina attorney, but I did look up South Carolina case law because that's what attorneys do. As soon as an issue comes up, they go and they look for case law, and we either find case law that we analogize, which means the facts are similar to the facts in our case, and we want to analogize the case and say, hey, look at this ruling. Like, our facts are similar, and so the judge should reach a similar end or a similar decision in our case. So we either analogize the case or we distinguish it. And when we distinguish it, we say, well, the facts were different, and distinguish a case that's, quote, bad law for you, or that for your client, that you don't want the court to look at when making a decision. So this, I'm going to butcher this name, I'm sure, but this Gilliam v. Foster was a 96 Fourth Circuit case related to double jeopardy. And just so we're all on the same page, most people realize this, but double jeopardy basically means a criminal defendant cannot be tried twice for the same crime, for the same charge. And so the manifest necessity doctrine kind of meant to guard against this. This Gilliam v. Foster case, again, South Carolina case, that then went up on appeal to the Fourth Circuit. The central issue revolved around whether the trial judge acted with, quote, manifest necessity in granting a mistrial due to the inadvertent presentation of unauthenticated photographs to the jury, which the defendants argued did not warrant such a drastic judicial action. So let's step back for a minute. It doesn't really even necessarily matter the underlying crime. I think this was like an assault case or attempted murder case. But procedurally, there's a trial, and I did go read the case. During a lunch break, I think some were left out that had not yet been authenticated and offered into evidence. And the jury saw these photographs. I don't remember exactly how, but they saw it. It wasn't by misconduct. It seems like it was generally, genuinely an accident. They saw these photographs. The judge ended up declaring a mistrial upon the prosecution's motion, and the defendant opposed that mistrial. The thing I should point out is that, let's just say in the case of Zachary Hughes, let's say he consented to the mistrial, then you don't have this issue. You don't even have to look at the manifest necessity. And quite frankly, with the way that this trial is going and the rather bold and egregious way in which Zachary Hughes testified today, there's a part of me that wonders, is that what we're going for? Are we going maybe for a mistrial? Because I was talking to my husband about this. He's a former prosecutor, but the case may not necessarily go back to Judge Fant. And again, not a South Carolina attorney, but the wheels are turning, and I'm thinking maybe the defense, it was a very unusual defense to put on, to testify in that manner. And I think, you probably know, Zach Hughes is in contempt of court for 6 months we didn't hear that because the judge is not allowing anything out of the presence of the jury to be live streamed. So we didn't hear the legal argument and his commentary to Zachary Hughes, but he held him in contempt for 6 months. Where was I going with that? They want a mistrial. At this point, legitimately wonder if the defense is banking on mistrial, get it in front of a different judge, and get a different evidentiary ruling. That's just where my head went to. I will say, have never really seen a defendant testify in this manner. It's an unusual case. Anyway, going back to the case law, Gilliam v. Foster. These defendants contended that a mistrial declared in the initial state trial was unjustified, thereby subjecting them to a second prosecution in violation of their constitutional right against double jeopardy. So jeopardy attaches when a jury is sworn in. And from that point forward, the defendant has the right to have his trial be heard by that jury. And if he has his trial in front of that jury and they find him not guilty, you commonly hear of like double jeopardy preventing him from being tried again on that same charge in front of a different jury. But if there's a mistrial, it's almost as if, jeopardy has already attached when the jury is sworn in. But if there's a mistrial, it essentially means it wipes out that jeopardy. It's like we're doing a reset. So in this case, the factual circumstance was that these pictures by the jury and they were not actually offered into evidence yet. And so let's just kind of read spoiler alert, but the Fourth Circuit, the appellate court, affirmed the district court's decisions to grant habeas corpus relief to the defendants, holding that the mistrial was improperly declared and that retrial would violate the double jeopardy clause. The court concluded that the trial judge did not exercise sound discretion. I can tell you right now that that's unusual for an appellate court to say that a trial court judge abused their discretion, as there was no evidence of prosecutorial misconduct or substantial prejudice that would justify the mistrial. Furthermore, the court emphasized that the alleged error was technical and could have been remedied without necessitating a mistrial. On the whole, a judge is going to try and avoid a mistrial like pure hell. They don't want to have to impanel a jury, go through voir dire, like they've expended a fair amount of resources. You're already that far in, like you don't want to declare a mistrial, but there are circumstances, manifest necessity, when a mistrial is warranted. And so in this case, the appellate court said, no, trial judge, you messed up. Like you could have fixed this in some other way. You did not need to grant a mistrial. You did not need to have a new trial. I am arguing that potentially in this Zachary Hughes case, and again, this is a very facts and circumstances driven determination, and there has not been a motion to my knowledge for mistrial yet, but if there were to be one, and the state and the defendant can move for that, so let's clear that up. Like the state can move for a mistrial. What would the judge be looking at? And furthermore, if that decision, let's say he granted a mistrial, and he found that there was manifest necessity, it was appealed, then what would the appellate court be looking at? And so in this case, so this was a South Carolina case, would go to the Fourth Circuit Court of Appeals, just like in our North Carolina cases, it's regional. Various states roll up to different circuits. But the court applied a deferential standard when reviewing the trial judge's decision to grant a mistrial, aligning with, it is Arizona v. Washington. I thought I wasn't making that up. It assessed whether there was a manifest necessity, considering whether the juror's exposure to unauthenticated photographs would have prejudiced the defendant's right to a fair trial. The majority of the appellate court concluded that the photographs were relevant and largely cumulative, meaning that, I think I forgot to mention, they had already offered in properly similar photographs. And it's like they took a break for lunch or something, and then these photographs were out, and so offering them in, or like they were relevant, they were admissible. It's just they hadn't laid the foundation and actually put them in before the jury saw them. And so it was like a technical error, essentially. It was not unduly prejudicial, lacking any undue prejudice that would compromise the trial's integrity. Moreover, the trial judge did not provide explicit findings of prejudice or manifest necessity, further undermining the justification for the mistrial. Hey, judge, you didn't need to do this. This judgment reinforces the robustness of double jeopardy protections because the defendant's constitutional right to not be tried twice is going to be, paramount generally, ensuring that defendants are shielded from unjust, from technical errors or oversight. It serves as a cautionary tale for trial judges to thoroughly consider the necessity of mistrials and to explore all potential remedies before opting for such a decisive measure. Additionally, the case emphasizes the supremacy of constitutional protections over procedural technicalities, affirming that the integrity of the double jeopardy clause. Oh, I just said it was God, look at me, go girl. In safeguarding defendants' rights. I really didn't even see that it said paramount, but there's these legalese words that we all learn and we just somehow repeat them our whole careers. Like paramount being one of them. All right. So anyway, where's that going with this? I thought there was a good quote that I wanted to show you. Maybe in the actual case itself. Yeah, so Arizona v. Washington was the landmark U.S. Supreme Court case that said, well settled, in a jury trial, jeopardy attaches. That means attaches is just a fancy way of them saying this is at the point forward, it's going to matter. The jury is impaneled and sworn. Once jeopardy has attached, a defendant has a constitutional right to have a particular tribunal, court, decide his guilt or innocence, jury in this case. For these reasons, a prosecutor is generally permitted only one opportunity, one bite at the apple, to force a defendant to stand trial. In certain circumstances, however, this right may be superseded and a defendant may be retried after a mistrial has been granted when the public's interest in fair trials designed to end in just judgments has been abridged. The Supreme Court has concluded that only when there is a manifest necessity for a mistrial granted over a defendant's objection, words matter. So again, if Zachary Hughes was to consent to a mistrial, then none of this matters. Will the prosecuting authority escape the double jeopardy bar? Manifest necessity for the grant of a mistrial is not a mechanical standard. Rather, it is a determination that must be made in the context of the specific difficulty facing the trial judge. And while manifest necessity for mistrial does not require that a mistrial be, quote, necessary in the strictest sense of the word, it does require a high degree of necessity. Perhaps the clearest example of a situation in which manifest necessity exists for a mistrial is when, ding, 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 a jury that has heard all of the evidence cannot reach a verdict, right? You got a hung jury, you're going to get a mistrial, like we saw in Karen Reed, right? The other extreme are situations in which a prosecuting attorney seeks a mistrial in order to have additional time to marshal evidence to strengthen the case. No, that's not. So that's not going to happen. Between these two extremes exists a spectrum of trial errors, some raising the specter of manifest necessity for a mistrial and others falling far short of creating a situation in which a mistrial is manifestly necessary. So this is what I was talking about when I said that an appellate court is going to grant the trial judge a fair amount of deference. The deference owed to the trial judge, however, is not unlimited. In reviewing the decision to grant a mistrial, this court has an obligation to satisfy itself that the trial judge exercised sound discretion. When the grant of a mistrial by the trial judge amounts to an irrational or irresponsible act, he must be found to have abused his discretion in finding that manifest necessity for the mistrial existed. So in the law, we often refer to, quote, bright line test. And sometimes there are bright line tests for things. You have to meet this, this, and this. Pretty clear. There's a lot of case law on it. It's well established. But other times you'll encounter situations where there is not a bright line test, and this is one of them. Manifest necessity is a very facts and circumstances driven determination. You have to look at it in the context of the trial. And so I think that this Gilliam v. Foster case, if Judge Fant were to grant a mistrial, and again, I don't think anyone is moved for one at this point. But if he were to grant a mistrial, um, I think that the facts in Zachary Hughes' case are distinguishable from this Gilliam v. Foster case, because this Foster case was just otherwise admissible evidence in the form of photographs that had just not been properly authenticated yet. Authenticated just means, laying the chain of custody, like when you get there and you say, hey, is this an accurate record of blah, 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 or is this you're laying the foundation to prove that this is admissible evidence. So in this Gilliam v. Foster case, that was the only issue. They just had not authenticated them yet. It was a kind of like a technicality. And the judge granted a mistrial over that. So I can see why the Fourth Circuit was probably like, hold up, you really didn't need to do that. In the Hughes case, we have what the judge has already deemed to be highly prejudicial evidence, and he had explicitly ruled as part of the pretrial motion, the motion in limine of the state to exclude the CP evidence, that no mention was to be made of this type of evidence. It was highly prejudicial, and the prejudice outweighed the probative value. So at a very high level, I think that if Judge Fant granted a mistrial based on this very highly prejudicial statements that Zach Hughes made, contravening his explicit evidentiary order, and repeatedly, and saying that the prosecution was withholding evidence, that's highly prejudicial. Interestingly enough, it's just such a rare and weird situation, because normally you're looking at this from a different perspective. Like, the state is offering in evidence that the state wants to get in evidence that's highly prejudicial to the defendant. And the state argues that the evidence is probative value greater than the prejudice to the defendant. So it's like a little weird because we're thinking of it in the reverse. But I guess my point is, I think that he could be within his bounds to grant a mistrial, particularly given the context of this case, the highly sensational nature of these allegations, the fact that he explicitly has, ruled in a pretrial motion that this evidence, because it is so prejudicial and so sensitive. So yes, I mean, the court could grant a mistrial. That's my to you. And I think it's disingenuous for people to say, oh, the state can't move for it. Yes, the state absolutely could. And while manifest necessity decisions are relatively rare, this is a rare case. Now, the last thing I want to end with is, I'm not sure the prosecution wants a mistrial, because, and I was going to recap all of his testimony, but I mean, it's a lot, y'all. And I said earlier that every time I listen to this case or read about it, I feel like I need to take a shower. And I really do, because there's just a lot of dirty. But I don't know that Zachary Hughes helped himself today, to be perfectly candid. It's beyond the bounds, I think, of. I think that the jury, if I were a juror and I were seeing him talk about being essentially forced to do this to save this child, and kind of the piousness, it has this kind of very almost God complex. Like, two wrongs don't make a right. And there were lots of means beyond stabbing someone 30 times. There were other ways that, he could have gone about this. And yes, he said he had called Child Protective Services, but I don't know that his testimony helped him. So my point is, I don't know that the prosecution even wants a mistrial. And I do wonder if the defense wants a mistrial and if this was not strategic because his attorneys are smart guys. And you don't normally see a defense like this defense of others defense, where you have a criminal defendant taking the stand and testifying in this manner, admitting to the crime, going into the crime in graphic detail. Um, I was reminded of, if any of you followed the Griffith case out of Florida, I covered it briefly a while back, and one of the neighbors who witnessed Colin and his mom arguing outside the grandmother's home. Like, I'm from Chicago. If we see something, we just keep on going. I'm paraphrasing, but she's like, we just, turn our head and keep going. It's kind of like, mind your own business. And I feel like maybe, I'm not saying he minded his own. It is egregious what has happened to this poor girl. Not Christina. I'm referring to the minor daughter. But this situation, it's like, what is that? I'm going to date myself here. The Salt'n'Pepa song, um, mind your own business. If she want to be a freakin' on the weekend. Oh, it's none of your business. Yeah. Anyway, I'm dating myself. I loved the 90s. Um, I kind of think Zachary Hughes should have just maybe minded his own business. And the cross is going to be enthralling. I'm going to be traveling, and I'm hoping that I'll have reception to where I can see it. But I'll try and do another recap video over the weekend. We're going to be away. But anyway, just wanted to give you guys my opinion on trial discussion. I do think that the judge could grant a mistrial. He certainly could grant a mistrial. And the state can definitely move for one. But they would be looking at the parameters of, is it manifestly necessary, or does the public interest dictate it? This is a rare case, as I'm sure you all realize, and so it might be one that qualified. All right, y'all. Thanks so much, everybody. Have a good night. Share this, please. Tell your friends. If you liked it, then give me a like and all that jazz that I said I would never, ever say. Okay.